2, 1.
Great. Welcome everyone. I'm Rahul Saxena. I'm the interim director at CreateX. Really happy all of you could come tonight to talk. We have such a great speaker, and I'll let Andy talk more about our speaker and the insights that he can provide. I know at CreateX we are Georgia Tech's student accelerator, helping students launch startups. We have a bunch of our founders here today that are in all sorts of spaces, of NFT, gaming, to VR, AR. So this is a really pertinent talk today. And excited that Andrew and the Georgia Game Developer Association could bring David here to talk to all of you. But we're those that don't know, I'll say one plug. We have our big demo day, August 25th at the Fox Theater. We're launching 100 startups this summer. And we're get a chance to meet and talk to a lot of these startups at that event across all sorts of industries. They've been working hard over the summer, getting incorporated and getting to product market fit, figuring out their customers and so forth. So if you get a chance, be sure to talk to them and network as much as possible, as we say, for any of the events that we hold, because this is a great group of people to have in a room in a specific area that is always hard to find outside of the public. So with that, let me welcome Andrew and let him introduce himself.
All right, and I'm going to see if the camera follows me around. This is an awesome camera. The owl. This is so much fun to have. When you talk out there, it's going to catch you as well. So you have to be quiet when the speakers are talking, but then be very clear when it comes to you. And that way you'll be big on screen for our thousands and thousands of viewers. Oh, we got some, but they're already asking questions, so it's a good group. All right, so I'm Andrew Greenberg. I'm the Executive Director of the Georgia Game Developers Association. Thank you very much to CreateX for co-sponsoring this event with us. This is very different from our normal events. At some point when this camera pans, you'll see what we have here. This is an invitation-only event. We're going for folks who are past the very initial phases of startup, but still essentially acting as startups. And very thankful, David Schulman from Greenberg Traurig, for offering his time. He has been very liberal with his time, very willing to help newcomers out. He's one of the founders of the Atlanta Esports Alliance with the GGDA and other organizations. Been very involved with game development, esports, and more in this town. Has become a leading game development and esports attorney. Certainly, he'll admit to the Southeast. Sometimes his coworkers will say in the South, but really in the nation. So we're very fortunate to have him joining us tonight. But before we get it to David, we do have a pretty select group of people. Again, this was an invite-only group coming here to ask questions. We will take your questions online. If you want to join us in person, August 9th, we'll be doing one of our more general meetings. We'll have Scarlett Dangerfield, head recruiter for Hi-Res Studios, as well as a representative from Skillshot at Gwinnett Tech for a meeting on how to break into game development and esports. So if that's what you're interested in, come out with us August 9th. The information will be up on our website, ggda.org. But today we're going to be more startup mode. So I'd love to go around the room and have everyone introduce themselves and their startups. So elevator pitch time. Can I start right over here, David?
Hey there, my name is David Baca. I make artificial intelligence girlfriends and boyfriends. It's called the Waifuverse. You know what Waifu is? You are in my target demographic, and that's the gist of it.
Hey everyone, my name is G, and I am the head of production for the Seneca project, which is the brainchild of this guy right here, and he can introduce it for us.
Hey, I'm Cozy, and I lead the Seneca project. We're creating a game, Seneca 7, that's an ARPG, like Harvest Moon meets Kingdom Hearts, that focuses on NFTs and blockchain and crypto on the thematic side through alien settlement to kind of teach people fun ways of how the marketplace works, like Animal Crossing does, but through like a cyberpunk theme, so off-chain education.
Yeah, I'm Ken, business development for this team. So,
Rich?
Hi there, I am Rich Crown with Bloomshine Media. a media research firm that creates value by developing technologies for entertainment and marketing. That's it.
Hi, I'm Garrett from PeerPop, and this is Tan. Lost his voice, so I'll just speak for the both of us. So we run an event ticket and promotion management software that allows any user to be a part of the promotional process and takes away the fakeness and adds real statistics for real pay for any promoter.
Hi, I'm Watson Hartzell. I make gumball machines that collect emotion data and sell it on an open marketplace where you're normally not being paid for this data. This is a chance to get a piece of candy for it.
And what's the name of the company?
Gumball Emotion Machines.
My name is Nish. I am interested in making an anesthesia assistant for the operating room.
Oh, you want me to say?
Absolutely.
My name is Ellie Young. I'm the founder and CEO of Access Replay now.
I'll get you to stand up. The camera's having trouble seeing you, and everyone should know who you are.
Allie Young, CEO of Access Replay. Second?
Okay.
Sorry.
We'll get you to come up and talk more about your upcoming event.
Okay.
Everyone's done. Hello.
Hi, I'm Raven Lundy. I'm representing Blue Scorpion Reputation Management and Athena Alliance, and we are a communications firm that communicates for gaming and other esports events and other things.
And online, we've had introduce themselves Maddie GFTW, Matt, who is head of Zen VR, a former CreateX company that teaches meditation in virtual reality, and Casey Loria, who is not willing to announce himself, even though he's got some really cool VR stuff that he is doing. So, Allie, before we turn it over to David, you want to talk about Friday's event?
Yeah, I would love to invite everybody. It's actually going to be at the TSQ ATL Social Club, which is right downstairs from here. And it's Friday, 3 to 6. It's going to be an awesome esports networking event. We'll have happy hour, food, and also Todd Harris will be there speaking along with the professional esports teams and orgs in town.
Excellent. For those of you online, if you want to introduce yourself, you're welcome to, and you can ask questions there. We'll pass them on here. David's going to do a presentation, and we've asked him to talk specifically about game publisher agreements, software development agreements, but I know that David's flexible, and if there are areas you would like explored, we're looking forward to it. Part of this is the Q&A. So David, thank you again for your time, and you can actually talk from anywhere you want, but if you want to go to the top.
Come on. I brought, I know this isn't good for the environment, but I brought copies of documents that I recommend if you guys just want to pick up copies. A sample development agreement, and then samples, and then a summary of video game publishing agreements. So a summary of issues in video game publishing agreements, which is really the backbone of the video game industry. So, and it's something where developers really lack leverage with publishers. And this will give you almost a checklist of things to think about when you're dealing, when you want to take your game out to commercialize it. So, as I speak on development agreements, you may want to have a copy of it in front of you if you just kind of want to look through those.
I appreciate you bringing those out. It's interesting for game companies, when you do have leverage is when publishers are desperately looking for something to fill their quarterly needs, or they have a very specific hole in their catalog they're trying to take care of, or they just need more content. I've been very fortunate with that.
Yeah.
Dealing with publishers.
And the market fluctuates. 3 months ago, content was gold. Now money is, people with good content could dictate terms. Now it's people with the money dictate the terms. So it definitely changes. Can you hear me okay? Can you see me okay?
People online say you sound good.
Okay, good. So in this environment, I assume that you guys get speakers on venture capital and corporate issues. So for today's topic, I wanted to talk more about intellectual property protection, and intellectual property commercialization, and specifically with the gaming VR industry in mind. But I also don't want it to just be a lecture. I don't have all that much. I mean, I have lots of things I can cover. But if you all have questions about something specific and you want to ask, or I trigger some thought, please just raise your hand, interrupt me. This doesn't need to be a one-way discussion. So first, I just want to cover the primary areas of intellectual property. So patents, copyrights, trademarks, trade secrets, and then generic confidential information. And each one of those categories gives you different types of protection. The industry that you're in, most of what you're going to do, particularly in the video game industry, is going to be trade secret related. It's not going to be, you're certainly going to generate trademarks, you're going to generate copyrights. The content that you're creating is copyrighted. It is a copyright that you own, but the code that you write, for the most part, you're going to protect as a trade secret. And what that means is, so a patent is something novel, non-obvious, must be useful improvement on existing technology. A copyright is a work of authorship. A trademark is a logo or a word or a set of that describe an origin of goods or the goods themselves. And a trade secret is something confidential and non-obvious that you use in your business that you also take steps to protect. So, and you get different kinds of protections depending on the type of intellectual property that it is. So a patent is a quasi-monopoly that the government gives to you, and it's 20 years from the date of application. But in exchange for getting that monopoly, you also have to disclose what your invention is. So that's the downside of it. The downside is that you have to disclose it, and that you also only get to leverage it for a limited period of time. Whereas, and frankly, Georgia's a great place to have a trade secret thanks to the massive corporation next door called Coca-Cola, where the Coca-Cola formula is a trade secret and has been for over 100 years. And they've leveraged it for that long. If it was a patent, it's not patentable, but if it was, it would have lapsed after 20 years. Source code can be copyrighted. It's often recommended that it be copyrighted, but you don't necessarily need to do that. Any questions so far? All right, so I'm going to jump ahead and talk about the development agreement. And all of you at some point in the industry will either give a document like this to a developer or receive a document like this from an employer or for somebody who wants to hire you. And these documents, the main reason for a development agreement is because copyright law works like this. If you are an employee of a company, all of your work product is owned by your employer. The work product that you create during work hours related to the business of the company, using the assets of the company, are owned by your employer. With contractors, it's the opposite. So they own all of their work product, even though you're paying them. When they deliver you their work product, you can use it, you can work with it, but it remains the contractor's unless the contractor agreement has what's called a work for hire statement in it. So you always want to have, if you are building a business and you are hiring contractors, you absolutely, from day one, And if you don't have it in place yet, go back to all of your developers and implement documentation that shows retroactively that the things that they did for you that you paid for are owned by you as the person who retained them. And this is critical as you build your business because you want to have a clean chain of title to your assets. And this intellectual property is the lifeblood of your business. If you get to the point where you want to exit your business and sell your company, one of the main questions the buyer is going to ask is, do you own this asset that you've been leveraging commercially? And when I buy it from you, will I be able to leverage this asset? And if you have not protected your asset properly, or you don't know, or you don't entirely own it, or somebody else can make a claim that they own parts of it, am I willing to pay for this asset and buy it from you not knowing the integrity of the asset that I'm buying? So it is critical to lock down ownership on the assets. You're paying people to create it for you. It is a reasonable thing to then also ask them to sign a document that says that the work product that they're developing for you is in fact owned by you. Now, the document can be big and complicated and have lots of things that a developer or that a contractor objects to, or it can be 2 pages long and all it has in it is the work for hire language. But you absolutely want to have that if you're building a business that's dependent on contractors performing work for you. And this is not just code. This goes to people who create music for you, people who create content for you, anything to do with your business that you're paying them for. You want to have that work for hire structure in place. So I gave you guys a document that I don't know the length of it. It's called 10 pages long. The ownership and work for hire language is all of a paragraph or 2. So you could take this document and boil it down just to those sections. But the document itself is intended to also protect the company that's retaining the contractor for other purposes as well. So it has, the other 9.5 pages or the other 9 pages in the document cover other things that when you retain somebody to perform work for you, you may care about. Ideally, you want to put it all in place, but I know that in startup world, in the creative world, people are sensitive. They oftentimes are concerned about signing legal documents. So if you only walked away with the work for hire clause, at least do that. The rest of the document has things in it like a description of the services and the work product that you're asking somebody to perform for you, a change order process. So if you ask them to develop, there's a certain set of specifications, but you realize over time that you want to modify them or you want to supplement them, you'll want to have a change order process. You're going to want to know that the contractor is subject to certain performance standards. The language that you often see, not just in contractor agreements, you'll see this in leases or in other types of contracts. The language of time is of the essence. That language is magical language in that it turns every deadline into a material aspect of performance. So if I say I want to release a game in the holiday season, and I know I need to have the development done, tested, beta tested, and submitted through a process by September 1st, and I write September 1st is time of the essence, and the developer does not deliver it to me by then, they've committed a material breach of the agreement. So this is a way, time of the essence language is a way of putting in place, making it clear that anytime there's a deadline in the document, it's a material issue that the contractor has to meet. Subcontracting, again, this goes to the issue of knowing around ownership and also the quality of performance. When you hire an individual or a company to perform work for you, you're doing it after you've done some homework about them. You believe that they're able to perform and deliver the deliverable that you're hiring them for. If they're going to hire contractors, you want to make sure that those subcontractors are able to perform at the same level. And also, you want to make sure that those subcontractors are subject to the same confidentiality and ownership provisions that your contractor is subject to. So you want to make sure all through the chain of performance, everybody's subject to the same legal terms when they ultimately deliver the work product to you. The next bullet is acceptance testing. This is a critical term. So it's also something that a lot of developers are quite concerned with, rightfully so. You want to have a process in place to test the deliverable that somebody delivers to you. So again, you want to make sure that you're paying for what you hired somebody to do, and you will test it. Now, the clause gets heavily negotiated because the company that's hiring the contractor will oftentimes want flexibility in determining whether something passes acceptance or not. Whereas the developer is concerned that they're going to be subject to the whims of the company that retained them, so that they're going to be told that they failed acceptance for disingenuous reasons, just as a way of not getting paid. Or because the company that hired them had a change in strategy or a change in preferences and priorities in terms of what they were looking to do. It also is a way of preventing, from the developer's standpoint, preventing scope creep, right? The company hiring them is going to constantly, they didn't necessarily know what they wanted. They may have changed their priorities or their strategy around a particular product or a particular game, and they may be coming in again and again with additional demands. So this goes to the change order process. This goes to properly documenting what it is that you are asking or being asked to develop, the specifications, the features, the functionality. All of these things are very, very critical. And in the acceptance testing, if you're the developer, you want to be very clear what it is that you're being tested against. What are the specifications that you're being asked to meet, making sure that they're objective criteria, not subjective criteria. When you're the company paying for the work product, you do want to have a certain margin of decision making, a certain margin of judgment. So it's a different perspective, and you just have to negotiate a proper structure. The next big bullet is obviously the ownership and the work for hire language. I started off by talking about that. Confidentiality, again, a critical provision.
I have a question for you. With devs being, near shore, offshore, whatever, can this apply as a contractor model for other countries as well, or are there tweaks that have to be made to it?
So, great question. So there are a lot of issues there. So first, you want to negotiate a choice of law, okay, with your contractor. So you want to negotiate Delaware, Georgia, New York law. But then there's a question of whether or not the country of origin would respect whether the court, if you were ever to enforce that contract with that contractor, well, you just signed an agreement that said Georgia choice of law and Georgia venue.
Right.
So something goes wrong, you bring action against that contractor in Georgia, you win the lawsuit, you've got a judgment, now you've got to enforce it in the foreign country. So does the U.S. have a treaty with that foreign country where that country will respect judgments in the U.S.? Is there an overarching reason why that country has a public policy reason that despite the fact that you won the judgment in the U.S., would they have a public policy reason to override, even though that contractor agreed to Georgia law and agreed to be subject to U.S. courts? So, and I'll give you a real live example, something I was dealing with 2 weeks ago. A client of mine, an NFT company, gaming company, is going to hire a CEO in Dubai. And we hired local counsel to advise us, and local counsel told us, So there are a variety of reasons why an employment agreement won't work because of local UAE law and the individual's visa in UAE. So that's a different set of issues. But he has to sign a consulting agreement, not an employment agreement, and we're going to be using local law because in this particular case, my client's in Florida. We wanted to use Florida law. The employee doesn't reside in Florida, has no connections to Florida.
Right.
He would have agreed to Florida law, but we didn't do that because if we ever had to enforce that agreement, we would have to do it in the UAE. So we have to have a document in place that will work in the UAE. By the way, it's also one of the reasons why a lot of Indian outsourcing companies have a significant presence in the United States.
Right.
So when you do outsourcing in India, you will sign the agreement between the American entity and the Indian entity will have a presence and assets in the US because there's a very specific way you have to do this, but generally speaking, Indian courts will not respect American court judgments. So you want the agreement to be with an American entity that has assets that you can enforce if you get a judgment. And there are other ways around that through arbitration and a variety of other things that are beyond the scope of what we're talking about today. But to your question, when you're hiring a contractor overseas, yes, you want to do it under American law if you can. But you also want to ask yourself, will that foreign jurisdiction, if something goes wrong, will that foreign jurisdiction respect the choice of law being the United States, and then ultimately, if there's a judgment in the United States, whether or not you can enforce it in that foreign country.
Got it, thank you. On a side note,
Okay.
because as a startup also, right, Upworks, like services like that, they typically have their own EULAs that you can utilize.
Mm-hmm.
Do those protect IP that you're wanting to get developed?
You have to read the terms of use.
So you mean like a Fiverr and Upwork if you hired them
Yeah.
for?
There are a lot of marketplaces that proactively address this point because they would not be viable if they played games.
Right,
But you want to
just
read.
double check.
You want to read the terms of use or the EULA. The fine print is important. I live in it.
That's what we have here.
This is a very graphic, if you guys know the South Park where they just randomly signed EULAs. I love that episode. Sorry, I'm juvenile. But it makes a point, and it's a very important point. And if you haven't seen that episode, go. I'm sure you can find it online.
It's called Humans in the Pad.
Yeah,
Illegally
exactly.
put up. Shared in violation of the EULA.
Okay, so going down sort of issues to think about with your contractors, the next big topic was confidentiality, critical term. You're developing something that you intend to leverage commercially. You want to keep it off the street, you want to keep it off the public domain until you're ready to go to market with it. So super important to protect its confidentiality. It's also a critical element in determining whether or not you have trade secret enforcement rights. So one of the two questions around enforcing a trade secret is it confidential, not known to your competitors? Are you taking proper steps to protect its confidentiality all through the chain of contact? Anybody who has access to it, are they subject to confidentiality provisions? The other question is also, are you making, is it used for commercial purposes? Next topic are representations and warranties. Again, a critical set of terms where you are asking the developer or the contractor to confirm to you that the work product that they're developing is either originally theirs, that they're the ones developing it, or do they have the authority to give you a ownership on what they're delivering to you. Making sure it doesn't have viruses in it. Making sure that their performance is at a workman-like standard. So, and these are fairly typical and customary representations and warranties that you're going to want to get from your developers, because if and when you were to ever sell your business, your buyer is going to ask you for these exact same representations and warranties. You're about to ask a question? Oh, sorry. I thought you raised your hand. Everybody know, do you guys know what indemnification is? Okay, so indemnification, an important provision. If something goes wrong, you are asking the party that you're contracting with to stand in your shoes and hold you harmless from the claim. Limitations of liability.
What do you mean by that? Like, explain like that situation and
So, I am a developer of a point of sale system for Kroger. And I just sold $30 million worth of hardware to Kroger supermarkets. And it turned out that I violated, and I'm NCR, I'm making this up.
Yeah.
I sold $30 million worth of printers or point of sale systems to Kroger. And NCR's competitor, Toast, comes in and claims, no, you violated our patent. So they'll sue Kroger, because Kroger's the violator, but then Kroger in their agreement with NCR, if they negotiated for an indemnity provision, will say, listen, but for my use of NCR equipment, I would not have been exposed to this lawsuit. So you, NCR, can stand in my shoes and defend me in this legal action from Toast.
this is on you, not me.
I'm sorry?
I mean, NCR saying that, or Kroger saying this is on NCR.
Correct.
Got it.
So it's a mechanism for shifting risk.
Yep.
And who's ultimately accountable. I'm sorry?
Pass the buck clause.
Put it where it belongs.
Who owns the responsibility?
Right.
So, and the arguments go like this: if I am the licensee, I just paid good money for a system and that I need to use, and I want to know that when I'm using it, I have the open right to use it. I didn't ask to get involved in the lawsuit, and you licensor have the requirement to do your homework and to develop this and to not infringe on other third-party intellectual property rights. And when you're putting it in my supermarkets, I want to know that I get to use it without any risk, such that if I am exposed to that risk, the licensor should have done their homework, should have made sure that they're not infringing. And because they were, or they allegedly are, they now need to stand in the shoes of Kroger and protect Kroger from that third-party lawsuit.
Makes sense. Understood. Thank you.
And I apologize to NCR and to Kroger.
The names and companies will not.
Just because it's next door, that's why I was
protect
thinking
the
about it.
innocent.
Yeah, exactly.
Understood.
I got a real life example for like some of us if you're acting for like contract work for identification. It's mainly a good example would be you get somebody to do like a track for your menu, and then it turns out that they took a large riff from a song. If they have the identification for the contractor that gave you that stuff and you had no idea it was a song, and you get sued for infringement, it's on the contractor, not you. So it's called a shit shield.
I haven't heard any of these terms, but I guess
All applicable.
pass the buck, shit shield.
Thank you for that.
Yeah, I've actually had to deal with that. That's how I know that.
Okay.
Well,
And that makes
And
sense.
it's one of the most expensive issues that you potentially as a licensor have to contend with if things go wrong.
That's why you like to go with, was it Oregon or Delaware for identification stuff? Last time I was
does
checking.
it matter?
Well,
Different states have different identifications.
Really?
so state law will govern. I don't know that one is better than the other. It depends on the circumstances. There's a question of what industry are you in and the jurisdiction where you're litigating. Do they have a lot of case law on the subject matter?
Portland with Dark Horse Comics is one of the
Okay.
real life examples I've dealt with too.
Yeah.
Identification is insane.
But a lot of people like Delaware, a lot of people like New York, so you get a lot of commercial litigation in New York, so there's a lot of case law. You have a very good court system in Delaware. A lot of
America's through Delaware, I believe.
Delaware, because of corporate reasons, again, beyond the scope of our discussion today, but they have a court of chancery. The corporate governance there is very progressive. They have a division in the state legislature which is dedicated to sort of forward thinking about corporate law. So they're very much in a leadership position in the country out of all 50 states when it comes to corporate law. So it's very common, particularly with public companies, for the benefit of management and directors to be incorporated in Delaware. But indemnity is much more fact specific. All right, so I'll move on. And I was about to start talking about limitation liability. So not all agreements have limitations of liability in them. It's fairly common in technology, license agreements and technology agreements. It is a way of arbitrarily picking a cap on a party's exposure. So I will enter into a relationship with you, but if anything goes wrong, I want to know that there's a limit to what my exposure is going to be in this relationship. There are generally two different types of limitation liability. One is an arbitrary financial cap, or just a number, or a formula for calculating a number, and the other one is limiting the nature of the liability. So generally speaking, limiting damages just to direct damages and carving out indirect damages, exemplary damages, punitive damages. And it's a whole topic unto itself. But it's very common in technology agreements to see limitations liability provisions. The next topic, which is quite a sensitive one with your contractors and with your developers, are the restrictive covenants. And specifically, I'm talking about non-solicit of employees, non-solicit of clients, vendors, and then also a non-compete. So in the employer-employee scenario, you oftentimes hear, oh, non-compete's enforceable, non-enforceable. You hear all these kinds of statements. Again, they are enforceable if properly written, in the proper context, depending on consideration being paid for them. And non-solicits are regularly, again, assuming that they are properly drafted, are routinely enforced. So when you're a contractor and you're hiring somebody to do work for you, if you're a company hiring contractors to do work for you, you want to make sure that they don't, if they're exposed to who your customers are and who your clients are, you want to make sure that they don't run off and offer them services directly and get around you. It's not so much an issue in the gaming space. So in the gaming space, the non-solicit of employees is critical, right? So employees, good qualified employees, good game dev designers, developers, artists, hard to find. And you want to make sure that when you're hiring a contractor to perform work for you, that they don't have or don't over time develop other agendas just because they're exposed to who your employees are. Injunctive relief, I think that's the last topic I'll cover on that agreement. So generally, you will use the court system to enforce agreements and to sue for money damages. So generally speaking, courts will provide you with a financial solution to whatever your set of claims are. But there are times when you want to ask a court to prevent or force the party that you're doing business with, to prevent them from doing something or to force them to do something. So, and it's to take an action. So injunctive relief is the mechanism that you would use. You go into a court and you ask for a temporary restraining order, and you then ask for injunctive relief as well. So if you think that your competitor stole your intellectual property and they're going to launch a product before you launch your own product, so you will run to a court and try to prevent them and you will make a claim that, and you'll try to show the court evidence of the infringement, and then prevent that party from going public with their product. So you're actually asking the court to ask the party to do or prevent it from doing something. So that's sort of my high-level analysis of a contractor relationship. I can talk about video game publishing agreements. I've got a document there that I developed over time. I draft a lot of those. I'm involved in a lot of them. It's really the backbone of the video game industry. So you have a lot of people who develop games, but the process of taking a game to market is complicated and difficult, and you can build the best game in the world, but if you don't know how to get in front of consumers, then it doesn't matter that you built a great game. So the publishing world, unfortunately, the publishers have a lot of leverage, and most publishers are still today developers or once were developers who figured out how to take their own products to market. So the biggest publishers today used to be developers 20, 25, 30 years ago. Some of them are still obviously active developers.
All right, we had a bunch of questions and comments on the contract agreements online, so we'll go backwards through these. Comment on Twitch. As a contractor, a non-solicitation is fine, but be careful on non-competes because you have no idea who their clients are. So I think the classic example is everybody publishes through Microsoft at some point, so gotta be careful you're not signing away your rights to work for other people. Number of questions about music in here. First of all, someone asked for you to clarify what music for commercial purposes means. I assume that's just music that's used in a money-making.
Yeah, I mean, again, the digital music licensing world is fairly complex, but again, somebody who writes a song or comes up with a melody, they own a copyright in it, and if you want to use it in your game or for commercial purposes, you need to get a license for it.
So there were comments about how does copyright and trademark work for music. It's pretty similar to everything else, but if you want to...
So trademark's probably not the right... So a trademark, again, is an insignia or a logo that denotes an origin. So, Nike, we all know what Nike means. It's a Oregon-based sporting goods company that develops sneakers and clothing at a particular level of quality and has a particular image. But a copyright is a work of authorship, and a work of authorship could be a poem that I write, it could be code that I write, it could be a song, it could be a movie that somebody, or a photograph, and that's protectable. So just the mere creation of something, you have a common law interest in it, and it's literally the word copy. You have the right to determine who can and cannot make copies of it. There's some exceptions to this, fair use and academia and some other scenarios, but once you create something, criticism, but once you create something, you have the right to dictate its usage. If you were to enforce a copyright, you actually have to file it with the PTO. You have to file it with the Library of Congress in order to enforce federal rights for enforcing a copyright. But the mere creation of it allows you to determine how it's being used. I hope I answered the question.
And I'll just add that for the musicians on the stream, you can negotiate specific agreements. So I've worked with musicians where we license the music for video games, but they can release the soundtrack separately. So you don't be afraid to ask for things if you think the game studio is not going to do anything with it. I'll add a personal comment on warranties for your amusement. I've gotten game publishers to take out the patent warranty because patents are so crazy right now with patent trolls, and obviously almost nothing I do will be covered by somebody's legitimate patent. Mm-hmm. So publishers realize they've never really had to deal with that, so they are willing to drop the patent, my requirement to warranty them on any patent infringements. We had, people are asking online about getting the docs that you're handing out here.
Mm-hmm. I'm happy to.
Are you handing those out as PDFs?
Yeah, email or digital.
Right. So there's a comment on the acceptability testing on Twitch. Someone said, get a period to cure. So
Right,
if you're the
so-
developer.
Yeah, so that's a great point. So acceptance testing should never just be a one-shot deal. So there should be a mechanism of going back and forth between the company that retained the contractor and the developer who's delivering the work product, where the company has to explain the errors or the lack of conformity in the deliverable and why it is that they're rejecting it. And then the developer should be allowed to go back and fix it and given a certain amount of time to fix it. And that process should go back and forth at least 2 or 3 times. And then you also want to negotiate the consequences of not meeting. If ultimately, if the deliverable is rejected, what are the consequences? Do you unwind the entire agreement and get a full refund? Do you get a refund just for the part that was non-conforming? Do you get a refund at all? So those are things that commonly get negotiated.
With similar comments on material breach, make sure you have a clause so you
Right.
can fix the breach. Something I commented was that you need a period at which it is accepted if it's not rejected. If you're the developer and they haven't given you an acceptance or rejection in 14
Right.
days or 30 days, you want that in the contract where it's automatically given if they don't reject, so you're not sitting there in pins and needles
Yep.
forever.
It's a great point. It's called deemed acceptance. Companies hate it because they don't want to inadvertently find themselves accepting something that they wanted to test and examine. But it is a good protection because otherwise developers are waiting and they're waiting for their payment that is often contingent on the acceptance.
Right, exactly. We did the material breaches one. The music laws, and it's just as easy. We're talking about the music side of it. Oh, if I missed your question in chat, please bring it up. I know there are a couple others that folks wanted to. Terms. I was going to bring this up. That as a developer, make sure you have some sort of terms in there and termination clauses intelligently spelled out, because at some point you might want to walk away, they might want to walk away. You might have them give you a kill fee if they decide that they are terminating it, so you've got time to find new business. But also, if it's your game, have a term in the contract, so at some point the rights go back to you, especially if they're no longer marketing the game.
So we're now talking about publishing agreements.
Oh, right. Publishing agreements. Sorry, I jumped.
Yeah, no. I mean, but you're bringing up really good points. They're all in the presentation. So again, if your publisher is not doing a good job for you, so let's go into the publishing discussion. So if you're a game developer and you need a publisher because you're unable to get to the market yourself, not all publishers are the same. So you want to examine the marketplace. There are some publishers who are great at MMOs. They're great at PC games. They're great at console games. Others are great at mobile games. Others are great at VR. So people develop their expertise in different markets, and you want to make sure that the publisher who's taking your product to market understands your market. You also want to know that what geographies they cover, because publishing a game in China is very different than publishing a game in Brazil. Localization, local rules vary tremendously, and the knowledge of the local marketplace and having the wherewithal to enter that market is very different, and not all publishers are the same. So you want to be very careful in terms of how you pick your publisher. And then what rights do you give your publisher? Are you giving them the rights to the game? Are you giving them the rights to sequels, prequels?
The entire IP.
Is it the entire franchise of IP? If they're not making a good market, if they don't meet some minimum level of royalties, do you want to be able to pull back their publishing rights, either completely terminate the agreement or just terminate some exclusivity that they have, keep them as a publisher, but allow yourself to also go retain other publishers? These are critical things to think through as you're entering into a relationship with a publisher. It's not enough that they just give you $200,000 to develop some piece of a game, or $2 million, or even $30 million. You have to make sure that the counterparty are able to deliver. Everybody wants a positive outcome, but if you have good content and you developed a good game and you're talking to multiple publishers, it's not just the amount of money that they're giving you. That's not going to assure success. The amount of money that they're giving you on the short term to build your game is a short-term judgment. You want your game to have a success arc of 5 to 10 years after you go to market with it. I know in my mind, I know I'm jumping around between topics, but these are important considerations. And if they're not performing, you want to have some reversion rates. You also want to think about, are you carving out esports? Are you giving them rights in esports? Are you giving them rights in peripheral products? Can they create t-shirts and mouse pads using the characters in your game? These are all considerations that you want to think through. And they're all in the presentation. So. Anything you want me to hit on specifically?
Let's break down a little bit more. You talk about geographic, and somebody's got China, someone's got Europe. But talk also about platform, because sometimes you'll deal with different publishers for console, for internet, and sometimes there are reasons to do exclusives or time-based exclusivity, or not be exclusive at all.
So I'll use Marvel as a good example. So I've done several deals with Marvel for Marvel games, and what they do is they have, their document is 75 pages long, but the first 10 pages are the business terms. So you have the business terms, then you have dozens of pages of legal terms, and then you have 250 pages worth of Marvel policies on how you're allowed to use their characters. And they've built some of the most successful and strongest IP out there. And if you're going to build a game for them, they want to make sure that it's done at the highest of standards. And what they do in this first few pages is they'll outline the key business terms that you want to think about or that they want from you. And one of them is determining what platforms. So if you get a license from them to use their characters in building a game, they will only allow you to do it in mobile. They will only allow you to do it in VR. They'll segment off those platforms.
That's a developer for each different platform? Or?
Yeah, if you look at the Marvel mobile games, it's a different developer than if you look at the console games. Now, that's changing. The market is changing. You're now getting cross-platform games. We'll see.
Is that their protection from not having all eggs in one basket? Or
yeah, and it allows them to charge license fees.
Creating a competitive sort of environment for each platform company is doing their best work, thinking they get. I was just wondering how and why that model, but I'm sure it gets the best of each platform for each developer.
So I'm not sure that a VR Marvel game would compete with a VR console game. So you could probably say
different
maybe
space.
It's a different space. It allows them to become a licensor multiple times and different streams of revenue. They also have such a rich set of characters that they will license out different rights, like the big Spider-Man Sony game from, I forget when it was, 2019 or 2018. That doesn't contradict. Let's say that was a console game on Sony. That doesn't contradict that doesn't prevent them from being able to license a Marvel Universe game to a different console developer. So it allows them to leverage their IP multiple ways. But to their credit, they don't spread themselves too thin, right? They only allow a certain number of games out there in any given, and these games hopefully have a long arc and a long life, but they, you don't see a new Lord of the Rings MMO game getting launched every year. Because it would ruin the market.
And they want longevity with what they're going to put out there into the marketplace.
And their games, they get a royalty stream for many, many years off of the games. So they would be cannibalizing themselves.
That's not random.
No. No. No, and gameplay is not random. I mean, everything you do in a game, good games keep you engaged, right? I mean, games that are too hard, you stop playing it. Games that are too easy,
It's not the challenge.
it's not the challenge. So, you know, you want to be brought along through the game, and you want to be continuously engaged over time. And different game platforms have different ways of keeping you engaged, right? If you go into a mobile game, you're going to see that the screen has 30 touch points. You're constantly looking at different things that you can do on the screen you're constantly earning. You're getting feedback from the game that you're overcoming certain challenges and that you're getting rewards for doing different tasks in the game. And that's a way that mobile games are very good at keeping you engaged. I mean, you know, different platforms have different ways. Arguably, that's one of the problems with VR, right? So VR also, the fact that you generally can't wear the headsets for more than 15 minutes at a time. They're very engaging. They're all encompassing. They have something to offer that other platforms don't, but they also have their
The headset.
the drawbacks.
Oh, yeah.
And the headset's expensive, and it's a single-use piece of hardware. And I don't know. I have opinions. I'm sure lots of people have opinions on these topics, but I'm happy to
You
go.
want to talk about royalty and payment structures on publisher agreements?
Great topic. So probably the single most heavily negotiated issue in a publishing agreement are what are permissible deductibles for the publisher. So ideally, right, so you put out a game and you earn $100, or the publisher earns $100. So first of all, what percentage does the publisher keep versus the royalty that goes to the developer? So, and then are you paying that royalty off of gross revenue or off of net revenue? So all publishers will only pay it off of net revenue. You can try to negotiate for gross. I recommend that you try. It's not common. So how do you calculate net revenue? So you have your top line, and there are things that are customarily excluded. So taxes, chargebacks, refunds, rebates, copies that you give that the publisher has to give out for free to trade organizations, bank fees, wire fees. You earn money overseas, you've got to move it back to the United States. You're paying wire transfer. All those types of overhead costs are commonly deductible. Third-party platform and third-party publisher fees deducted from gross revenue. But then you get into the more, and then you start getting into sort of the more questionable ones. But before I start addressing those, there's also something that a developer should do is negotiate some non-recoupment amount. So you want to make sure that some amount of the money that you're getting from the publisher, you can keep yourself for your overhead. So you want to have some of that money be non-recoupable. You also want to negotiate very specifically that some amount of the money that the publisher uses to promote your game is going to marketing. So you want to challenge your publisher and tell your publisher, show me your marketing plan. Show me your marketing plan before you go to market with it. We know our product. You know the market, but we know our product, and we should coordinate what that marketing plan says and does before you take it out to the market. And you want to know how much money they're spending on the marketing. And you want to know that the marketing dollars that they're spending on your game are dedicated to your game, not to the entire group of games that publisher publishes. So they may have 30 games that they publish, and they're telling you, well, I'll spend $500,000 in marketing, but it's out of my general marketing pool. Well, that doesn't do you any good, because you want to know that it's dedicated to your game. If you're talking to Epic Game Store, you want to know that, and And Epic Games, they had a platform, it used to be called Diesel, now it's called Epic Game Store. They were buying up content, right, 2018, 19. They were out there and they were paying a lot of money to get exclusivity off of a lot of games to make sure that it was being published with them and not with Steam. And when they were doing that, the companies I was representing that were dealing with Epic, we always said, okay, we want to know what your marketing dollars are going to be. It's not enough that you're paying us for exclusivity. We want to know that our game's going to be successful. We want to know that you're going to have traffic on your site. We want to know that we have exposure on the top landing screen when you first get there, not that you don't have to scroll down to see the marketing information. So these are critical things because it's not just enough that you got paid a bunch of money to have, yes, it reduces your risk by having a publisher put up the money, but you want a successful game at the end of the day, and that's where your lion's share of your revenue is going to ultimately come from. So,
can you put guaranteed minimums?
yes, absolutely. Absolutely. A lot of deals that I've done in foreign countries with publishers that we're not particularly familiar with, there is a licensing fee. And that's what Marvel does, or at least the deals that I've done with Marvel, I've always seen them require a licensing fee. So, you know, success or not, you'll get paid something for giving away a chunk of the market.
Now, that might be an advance against royalties or not.
Right.
So you have to keep
So
that in
that's,
mind too.
yeah, so it's almost always an advance against royalties in one form or another, and that's why I said that some portion of it should be non-recoupable. So then when you start talking about the deductions, what are the ones that are much more questionable? So if you're a publisher, you want any third-party expenses to be deducted. You want QA costs to be deducted. You want all the marketing costs to be deducted. And here's where the developer can really find themselves at the end of all of those deductions getting, maybe they're getting, you know, significant royalty percentage, but you never actually get down to or there's very little left by the time the publisher's done all of their deductions. So you have to be quite careful about that and quite very specific when you're negotiating those terms. And it's critical.
Another agreement we've set up before was a laddered agreement where it was just based on unit sales, where you got rid of everything that's back in the COGS days, back in the cost of goods days.
Well, you still
just
see that.
eliminate
You
all
still
that.
see a lot of agreements when you talk about retail sales and cost of goods that gets negotiated. And cost of goods sold is a standard deduction. Again, it depends on what the definition of cost of goods sold is. But when you're talking about retail sales, that's a typical deduction. But it's critical, right? Because every single one of those items, and going along with the royalty deductions, is you want to get financial reports. So you want to get financial reports, and you want to be able to conduct audits, which publishers absolutely hate. The idea that a developer is going to come in and audit them. But I've done some very significant, I did a AAA $58 million publishing deal with a very large company that everybody in this room would know, and I represented the developer, and we have auditing rights. And we get financial reports, monthly and quarterly and annual.
And if the audit finds a certain
Is that
discrepancy.
available for, I mean, you gotta negotiate that in.
You have to know to ask for it.
And you can also ask, and always get this, for the publisher to recompense the audit if a certain level of discrepancy.
Right.
I ask for 10% or about 10%.
I'd go with
so forth again.
5 is usually the standard. If
Yeah.
there's a variation of greater than 5%, then usually the company that was subject to the audit would pay the costs of the audit. Because that becomes sort of a default materiality. Forget, you triggered a thought that something, a topic I wanted to cover.
Do you see data coming back to developers or anything there, or just usually the licensor owns all those rights?
It's a really good question. So the user data, like the public,
Yeah.
it really depends on the policy of the publisher. So in the console world, the console owners will tell you that they own the users. PC, it's a little different.
PC, there's more AI in games being used where the games could get better as the AI sees the data treating on that. Is that?
So it depends on what part of the game, right? So I'd tell you that probably the in-game marketplace is, yes. Match, you know, a lot of it doesn't have to rise to the level of AI, right? I mean, matching up, you know, if you're going into an instance and your team's playing another team and matching up the statistics of, you know, the profile of the player and the user and their character in the game, probably doesn't require AI, but marketplace auctions and you get some very sophisticated, and there are companies who, you know, Epic has, you know, Epic Unity, they have the game engine, so a lot of companies are now getting into the middleware, the next layer of gameplay. There's companies out there that are trying to become licensors so that game development shops don't have to recreate all of that every time they want to build a game.
On the mobile side, do you see publishers successfully getting user data from the app stores and passing it on?
So when I represent developers, we always ask for data. And it's important for the game, and it's important for the publisher to share. I did a deal, I mean, I'll speak about this publicly because it's very positive. I mean, I did a deal with Tencent where Tencent shared, I mean, they have probably more data than anybody about video games. And they did a deal with one of my clients where they shared information on gameplay that was critical to the success of my client's games.
To the success of it?
Yeah, I mean, they shared information about what works and what doesn't work in games because they've got all that data from dozens and dozens of games that they developed or publish. They know what works. They know that tension, that the proper tension that's in a game that keeps a player engaged. And if they're going to publish somebody's game and they don't think that that's there, and they're willing to share that information, that can be quite helpful. Right, and that's a good reason to pick them if you're going to enter the China market. Other than the fact that they're a behemoth and they dominate that market. I mean, NetEase is a competitor, but it's a tenth of the size.
For data stuff, you guys, is it Death Stranding, the game with the strange alien baby we're walking around? It's a massive data collection farm for Boston Dynamics and other things where you're actually testing scenarios for their bulldogs and whatnot. So data collection has now gone from just player database into actually using the player base through gaming to crunch real algorithmic data and send back. So Death Stranding is probably one of the first ones on the forefront of the data collection. EULA, legalese train.
Yeah.
Well, the VR data collection is crazy too. Just the eye tracking, what you're doing every second in.
There's another side to this, which is the game, you know, the game developer wants to enforce their terms of use. They want to make sure that people behave themselves in the game, that they're not saying outrageous things to other players, that they're not introducing bots into games. So, you know, and that is a process that if they're not self-publishing, they have to coordinate with their publisher.
You want to talk a little about terms and termination and publisher agreements?
So, yeah, and I'm going to actually grab a copy of this because I have an outline. I have an outline of things to talk about to the people in the room who have this document. Go to section 17. And so obviously there's the typical termination rights, which are termination for breach, termination for bankruptcy, and termination for convenience. You want to avoid having terminations for convenience just because these are documents that get heavily negotiated. You want to have long-term relationships. You don't want people walking away after you know, assumed that you were going to have a 5, 6, 7-year relationship with your publisher or with your developer. So you want to think very carefully about terminations for convenience. But certainly, there was a good, back in, the Me Too movement, when it, obviously still a relevant topic, but termination for reputational reasons is something that you will see in video game publishing agreements that you don't see in a lot of other, like, you're not going to see that in the contractor agreement. Because it's not a consumer-facing relationship. This is a consumer-facing relationship, so you think about, I'm trying to remember the name, where there was there was an Easter egg with some profanity in it and nudity, and it was very embarrassing for the publisher. I'm trying to remember the name of the game.
There's the old Doom Easter eggs from it back in the day.
Right.
That's one of the ones you're thinking of, with the secret room with the naked lady.
That may have been it.
And Hexen had some too.
Yeah.
Back in the day, the Wild West.
Yeah, but I was thinking, what's the car racing game?
Oh, there's
Grand Theft Auto had an issue.
Oh, the hot coffee mod? I just didn't officially ship with it, but shipped with it. Yeah, hot coffee was their more adult side, which was still in the game, and they thought they'd locked it away, no one would find it, which was a vain hope at best.
Yeah.
There's nothing that will not be found in your software when you put it out in the world.
So termination for reputational reasons. So publishers will oftentimes have the following scenarios. They'll want to know that if their developer has a change of control, if the developer gets sold, that they have the ability to either buy out the franchise IP or terminate the agreement because they don't want to necessarily deal with a different owner of that same developer, or because the industry is not all that big, the buyer of the developer may be a competitor of the publisher. So the publisher will oftentimes reserve the right to terminate the agreement. They may still be required to pay royalties, maybe a lesser amount of royalties, but they'll oftentimes still be required to pay royalties. But they are then allowed to terminate the agreement and either self-support, hire their own developers to support the IP, and they get one, aside from the change of control, would be just a payment of a kill fee, right? So the publisher may say, well, I've spent so many years with this developer, I either don't like the way the developer is doing the development work, or I can potentially generate more revenue by supporting this myself. And after 7 years, they have the right to then come in and pay a kill fee and take over the IP. I've seen both of those clauses. Usually the developer will insist that they get a certain number of years worth of royalty before they'll allow the kill fee to be triggered.
And if it's not, the developer, if it's not their IP, should probably ask for their own sequel right from the publisher. If the publisher comes to a developer with a project.
Yep.
Developer should ask for that first right of refusal on the sequel.
So one of the things that gets negotiated is whether or not you get the publishing rights to the specific game or for the franchise. And if the publisher does not get rights to the full franchise, they will almost always negotiate for rights of first refusal on publishing the next game. And it may not just be from the franchise, if it's related to the initial game. It may be any game that developer comes out with, the publisher is going to want a first look right, a first negotiation. Sometimes, and I don't recommend doing this if you're the developer, but sometimes they'll also have a right to match the last offer, which is a way of chilling the deal to an extent that I think it actually would kill the ability for the developer to actually go to a third party. So I don't recommend doing it if you're a developer. Just practically speaking, it's a very hard hurdle to overcome. So, covered a lot of topics.
Mm-hmm.
Always happy to answer emails, happy to take calls if people have follow-ups. And
this is outside of what we were talking about, but the conversation was going online. Do you have any thoughts on COPA? Is there anything in publisher agreements that ever address COPA, or people just figure they have to follow the Children's Online Protection and Privacy Act?
It depends who you're targeting with your game and who your audience is. Comply with COPA. Right? I mean, that's an easy one.
Just go after 13 and up.
Right.
Make it easier.
Yeah. I know that
Sorry. Off of COPA, do you know anything about BIPA, or have you?
I actually had a client get sued for it. You know, it's interesting. It'd be interesting to see how that develops.
Mm-hmm.
I'm sure you're facing that, right?
Yeah,
No pun intended.
Biometric Information and Privacy Act.
And there's different states with different laws, and actually a client of mine with, I don't want to talk about it too much, but with a help desk application, got hit with an action, and we overcame it actually.
Is that something VR has to look out for even more?
I think ultimately, the plaintiff's bar is going to try to make hay of it.
Okay.
And unfortunately, it's something that the industry is going to have to deal with.
We've got a few VR developers in the online chat. Any special areas that VR devs or publishers need to be aware of?
So VR is an interesting niche because there's this, it's not a fully mature niche, and you end up, the hardware providers and the software developers need to coordinate, and there is a lot of opportunity to strike up really good relationships with some of the large hardware manufacturers, get a lot of headsets to test things out with, and to work cooperatively with some of these really large companies, and I recommend that VR developers do that and pursue it. You know, whether it's the graphics chip manufacturers, the headset manufacturers, I mean, there are a lot of people out there that are trying to develop the next thing, and I think good developers with good ideas and good applications have an opportunity to really work with some mega companies that are developing hardware. So that would be my recommendation, because I've done quite a few of those partnership agreements where much smaller software developers get to work with really big hardware companies that are trying to test out new hardware.
And I know we have a number of AR developers in the room. Any special areas AR folks should look out for?
Great question, yeah.
I mean, I'm very excited about AR. I think AR is a really huge opportunity that we just haven't seen a lot done in, or I haven't. Love to see more. I mean, is there anything specific?
No, I was just saying, like you say, is that as new as a category, or like very not fully developed like AR? I mean, like VR. Or are you just seeing the applications?
I think VR and AR, in terms of the devices, and then the developers working with the device manufacturers, I think they're in the same bucket. And I think that is. I think there's a lot of room for growth. I think there'll be a point in time where we interact with our environment with supplemental screens and computers. I don't think that's all that far away.
To the AR thing, it's going more than just camera manipulation,
Right.
Where it's also.
I think that was where I was just seeing the initial.
They're big developers that are creating technology pieces that are patentable, that are looking for content creators. For example, there are heat mapping that are working on the Z-axis in buildings to where they'll be able to actually go into and in your game and whatnot, like Pokemon. You have the geofencing strictly like that, but now there's people with technology widgets that are looking for content for augmented reality that deal with the Z-axis of going up in high-rise buildings. For example, being able to have that level of depth to AR. That is now the new movement in at least game development for the next, like last year and this year that's where it's kind of heading. They're really interesting into AR. So it's gone away from the camera into using the device as a whole to interact with your world environment.
In that environment.
Yeah, to even when I worked with a company, it was they did they're part of like the rideshare system. They wanted to implement gaming while ride sharing was going on, to where the AR was happening while they're driving and riding. So the reality is being augmented more than just the lens. So there's a lot of opportunities for that.
Yeah.
Very cool.
I think I don't see more questions in the online chat.
Well, thanks for doing this. Rahul and Andrew, I should have thanked you guys when I started, but it's just tremendous, and thank you for putting this together, and happy to, if anybody has follow-up questions, emails, happy to help out.
There is a question online, any case of patent trolls in VR or AR? Oh my goodness.
I'm not aware of any. I'm sure there are. I've not seen any, but
I can't believe there aren't.
well, I'm sure there are.
The cases just haven't been hitting because there aren't enough applications out there to make it worth the trolls' while yet. So many trolls make their money by just blanketing them all out and getting what money they can.
Yeah.
They need a lot of folks to harass.
Yeah, I think you'll see a bunch of plaintiffs' cases in BIPOC, unfortunately. That's going to happen.
All right, well, you in the room are still welcome to ask questions. I have a feeling some of you were waiting on your questions till we were not live and broadcasting
Are we
to
off?
the world. Nope. We'll go ahead and thank you very much, David.
I don't know. I mean, it's meet the lawyer. I don't know how exciting that is, but
What a great online. Take care, everybody.